I've often told clients I've won cases I should have lost. I've lost cases I should have won. Now, Lydia, you may have heard this story, and if you have, bear with me. This is about a case I lost and I won. I won the case, actually, but I lost more than I won. It was a small claims case. My client had worked for a big employer, and they had shorted him on wages about $480. So he had asked, to be paid and so forth, and they hadn't paid him. So he filed a small claims action. And a big-time law firm filed a response basically asking the court to dismiss the case. And it was, a motion to dismiss with attachments and everything. So he comes to me, doesn't know how to deal with it. I responded to their motion, which took quite a lot of time. I mean, it was a very extensive motion they filed, and so I had to do likewise. And the company, in the meantime, the reason they moved to dismiss was they had paid his wage. They'd give him a check for the $480, and so they said, "Gee whiz, we paid it. Should be dismissed." Well, that's not the law. That's not the statute, the way it reads. And so I had basically answered that in my motion to respond. And so the court approves our motion and disproves, or doesn't disprove, denies their motion. So we set it for trial. So we go to trial, and the statute allows that you'll get 3 times the amount of whatever money they've shorted you. So you also get attorney fees. The statute's pretty clear. So we go to trial. I put on all the evidence that I knew that I needed in order to win the case. Client testifies that he asked for payment, that he brought it to the attention of his supervisor. They filed a grievance. He went to HR, no payment. And so finally he filed suit. They put on a couple witnesses, HR, and they put on his supervisor. So I cross-examined the supervisor with the documents that were in evidence. And I got him to admit that he knew of the shortage, and he admitted that my client had asked him multiple times to be paid, and he'd ignored it. He admitted he had ignored it, but he wouldn't answer why. I asked him, "So why didn't you pay him?" And he just stared at me, sullen, refused to answer. So I won the case, and I'd asked for attorney fees. And I asked for like $7,100, which is pretty significant for a small claims case. And in fact, usually small claims anywhere from $500 to $1,000, depending on the case. But because of all the motions, and there were other motions and stuff I had to do, the fees went up. Now, I didn't charge my client that. I mean, I charged him that, but I would not have collected that from him. And I told him going in, I said, my fees are going to really go up on this. I said, but I'm not going to ask you to pay it. You're going to be on the hook legally, but ultimately they have to pay it because of the statute. And so imagine my shock when the court denies my motion. And I remember I walked up to the bench. I said, "Judge, here's the statute." And I literally read the statute to him. It says, "A plaintiff who prevails shall be entitled to attorney fees." And I emphasized the word shall. I looked right at him. I said, "Judge, it says shall." He just ignored it. Absolutely ignored it. Well, I could have appealed and won, there's no question. Defense attorney knew I was in the right. Judge knew I was in the right. I knew I was in the right, and definitely the appeals court would have known. But, life was busy back then, and I was involved in several federal cases. And the other thing is, there's a word in that statute that would have really hamstrung me. It says the plaintiff is entitled to reasonable attorney fees. Well, the word reasonable is pretty vague. Now, I think that it was reasonable. I even put another attorney on to testify that my fees were, in fact, reasonable. But the judge has almost absolute discretion. I knew that even if I won on appeal, we'd be back in there arguing, and he would give in to the appellate court's decision, and I would end up with 500, 600, 1,000. Even if I'd have got only $2,000, I would be money in the hole because of all the expenses and time and effort on doing the appeal. So for me, it just wasn't worth the effort. And like I say, I was involved in several federal cases, so I just let it go. Charged the client, I think $500. They paid him, $1,500, something like that. So most everyone went away satisfied. He made money on the deal anyway. Well, here's the application. You're going to run into people in life who make life difficult. They're unjust for whatever reason. They are just going to be that way. They're going to do you wrong. And sometimes you just got to move on in life. You can't fight every wrong. So, fortunately, we're going to all stand before a judge one day who knows the law. In fact, he wrote it. And he's going to give a good, fair, just ruling on your case and my case. And there's actually a scene depicted of that event. It's of this judge on the bench making a ruling. You can read about it in the Bible in Revelations chapter 20, I think beginning in verses 11 or 12. Fascinating. Most fascinating scene in all the Bible for me. Maybe it's because I'm a lawyer and this is a judicial scene. I mean, you've got a judge sitting with defendants spread out before him, and he issues a ruling. Fascinating. So, all right, until next time, thanks for listening.